Hello and welcome to the Virginia Assembly. My name is Lorraine Ham. I am the speaker here on Virginia, and our moderator today is Bradley Odell, our state coordinator, and our speaker is Randall Rimby, our state sergeant at arms. Welcome, gentlemen, and take her away.
Thank you, Lorraine. Randy, good to have you today.
Thanks. It's good to be back, Brad.
Let's have a little talk about Roman civil law versus American common law, if you don't mind.
Sure. Well, in
right.
simple terms, oops, sorry, did I interrupt you?
Nope, you're good. Go ahead.
Okay. In simple terms, Brad, Roman civil law is not really a law at all. All of their so-called laws are actually corporate policy for commerce. They're called statutes, codes, mandates, and ordinance that we've all been trained to say that is their law. Here's the difference. Their statutes and codes are legislated by the government, and there's no consent of the people for those laws that are legislated. They create those statutes, codes, and ordinances, etc., to control men and women in the name of safety, but without the consent of the people. This type of law pertains mainly to U.S. citizens that particularly have privileges if they obey all of those codes, not to sovereign men and women like those of us on the land and soil. For example, when is the last time you consented to a license or a fee, particularly for things that should be free that have been granted to us by our Creator, such as hunting licenses, fishing licenses, dog licenses, and fees for going to state parks, fees for anything that you pay for that we feel like should be free. Those are things that are legislated by the current de facto government that we acquiesce to based on their legislation. Conversely, in American common law, the laws are debated, written, and voted on by the consent of the people. The foundations of those laws being embedded in, number one, God's laws. These are the Ten Commandments and the relating type of ideas that go along with it. Natural law. This is the difference between right and wrong, the self-defense and freedoms and liberties that have been granted by our Creator. Public law, which involves previous case precedents. And of course, our notables are the Declaration of Independence, the Bill of Rights, the original Constitution. All of these things were designed to protect our God-given freedoms and rights, such as life, liberty, and the pursuit of happiness. I will mention a few other foundational things that I think are important. The living man and woman has absolute rights over their property, including land, chattels, and intellectual property. There's not supposed to be any eminent domain tricks that the federal government tries to play, taking people's land for their purposes. Men and women are required to have explicit consent of any agreement or contract without duress or coercion. Take, for example, the traffic stop. You are coerced aggressively to hand over any information and to sign the ticket because you violated one of their state statutes and codes. Every man and woman has the right to enjoy their property without unreasonable interference or nuisance. A couple examples of that are, did you vote or give consent to the seatbelt law? Did you vote or consent to give yearly car inspection, car registration, traveling as opposed to driving? We never consented to any of that. It was just legislation that was put forward by the de facto civil law government to control us, again, in the name of safety. And finally, men and women are not bound by statutes and regulations that would entangle them in legal fiction or corporate entities. Remember, a U.S. citizen is considered a corporate entity. And so when you're living in that world, that U.S. citizenship, the federal government has control over you by these statutes and regulations because you are, in fact, part of that corporation. So I hope that kind of explains the basic difference between the two, Brad.
Yes, sir. That did help. Next question. So how does this application of these two forms of law affect our judicial system?
Okay, a quick overview. Roman civil law is the foundation of sea jurisdiction, admiralty maritime, and air jurisdiction, papal and municipal law courts that U.S. citizens are currently living under. Currently, there's one common law court standing in Virginia, and that's our state common law court. Hopefully, at some point, the word will get out, and we'll be able to take on court cases in our world. But this form of law policy is based on the assumption that you will acquiesce and not rebut against the charge against you. This is considered agreeing to the charge in their world. They put out the legislation, the statutes and codes, sometimes secretly without anybody knowing, and you don't know until you violate it and you're arrested or have to pay a fine, fee, or show up in court. In addition to that, judges arise from private practice and are appointed by the state, which allows them to use their authority independently of the executive and legislative branches and the foundations of common law. This means they have no connection to the men and women in their jurisdiction. They're beholden to the people that pay them and give them the jobs, and that's the maritime and municipal corporations that appoint those judges in those positions. Whereas in common law, the common law binds government officials and employees to serve the people. What does that mean? Well, judges are elected by the people, not appointed, and they can be and should be removed from office at the first sign of negligence or corruption against the foundations of common law. They can even be charged with a trespass against the people by doing that. So we hold them accountable for their seat to be able to protect the rights and freedoms of living men and women. In our world, the common law world, they're known as justices, not judges, sometimes magistrates. It is their responsibility also by their opinions to dissuade other branches of government from exercising unlawful power. And we know that those Roman civil law judges love to not remind those other branches to not exercise that power. We're being overpowered every day. Hope that helps.
Yes, sir, and we sure are being overpowered. Can you tell me what the difference is between the American common law and the Roman civil law in the courtroom?
Sure, and this is a biggie, and I'm only going to skim the surface here. There's a lot to unpack. I'm going to try and keep it simple. So first of all, American common law courts are considered adversarial. So what does adversarial actually mean? I'll describe it in two ways. First, in American law, you are expected as a sovereign man and woman to self-govern yourself. The claimant and the accused, and that's what you are when you enter a court. You're either a claimant or an accused. You're expected to debate each other with the factual evidence that you accrue from the circumstance that you had to go through. And you can do that with the assistance of a counselor. The counselor argues their evidence to the jury on their own behalf. The counselor helps to assist them in that regard if they need it, but basically the counselor doesn't speak for them. The claimant or accused has to do all the speaking. And all this to be able to arrive at a remedy if it's a civil jurisdiction case. If it's a criminal jurisdiction case, the decision by the jury will be the guilt or innocence and the remedy. And secondly, in speaking of common law counselors, the common law counselor in our world, in the common law world, owes his absolute loyalty to his client, not the government. The counselor doesn't speak for their clients. They only advise them during their testimony. He leaves the determination of the facts in the jury's hands. That is guilt or innocence based on the application of the foundational laws. Remember those laws I listed earlier. There are no plea bargains in our world. A plea bargain is basically a trap for you to acquiesce to a softer charge in order for you to plead guilty so that the court can proceed. So we don't plea bargain in our world. And also, as pertaining to our county courts, there's no appeals. Decisions are final by that jury. The claimant or accused cannot appeal their case in that regard. Well, let's move over to Roman civil law. So in contrast, again, remembering the maritime municipal law trials are inquisitorial. They're inquisitive, meaning the judges and attorneys of both parties are in an investigation to discover the facts according to the notion of the statutes, codes, and mandates that they've charged you with. In other words, they want the evidence to prove their charge. In other words, you're guilty as soon as you walk into the courtroom, because you're charged first, and then they like to take the evidence and find the evidence to get you charged for what they charged you with initially. There is no leeway for using foundational law to find you as innocent first. And a player in this part is the bar attorney. Remember, bar stands for British Accredited Registry. So bar attorneys or esquires have been schooled in British law, not common law. So they don't understand or don't want to understand our language in common law. They use legalese and Black's Law dictionaries to skew everything they talk about. But the bar attorney is loyal to the state or the chief of state or the city council in which they work. That's who they owe their allegiance to, not to the common man and woman. In these tribunals, attorneys are using the statutes and codes to find the evidence that supports them, and then tries to convince the jury of either guilt or innocence based on those arguments. So I hope that helps you to kind of understand the basic difference of how each of the courts work.
Yes, sir, that sure did. Last question for the day. Can you explain how the deliberation process of the jury is different in both jurisdictions?
Thanks, Brad. That's a great question. I think this is one of the most important questions of the day. In our world, the jury verdicts in American common law are evidence of the law's discovery. So remember the foundations of common law we discussed earlier. All the jury has in their mind before they get into deliberation, all those foundational laws. So when the evidence packet reaches them, or after they've listened to each of the claimant and accused testimony, the first thing they do, the jury will reveal the specific foundational laws and how they apply to the past events that have risen from the evidence that they've heard, the circumstances and relationship presented by the claimant and accused. What this means is, in our world, if a claimant or accused is making a claim and it doesn't fit in the foundational laws, if the claim is not violating any of those foundational laws, the case can be dismissed. On the other hand, if the claim that's being made by either person does violate any of those foundational documents that I discussed earlier, then they will be found guilty and or owe remedy to the person who is bringing the case. So that's really important. What that means is you are considered innocent until proven guilty. In addition to that, our jury considers the facts only. Emotion and the what ifs, ands, or buts, or ors are left out of the deliberation. And here's why this happens. We all know, we've heard about professional witnesses, professional claimants and accused, how they overreact to things that happen in a way to tug on the heartstrings of the jury. That's dishonor as far as I'm concerned. Our jury only looks at the facts only. They don't allow emotion. And jurors are instructed and to remember that they don't bring into the conversation, but what if this happened, or what if that happened, but yeah, if you'd have done this or whatever. That's all hearsay. Hearsay is not evidential fact. And so as the jury is deliberating over the factual evidence from the claimant and the accused, by leaving out that emotion and leaving out the hearsay, they're able to look at the evidence in front of them critically and determine the guilt or innocence or the remedy based on actual evidence. The other really cool thing that our jury can do is they can nullify. Now, they can nullify a law or a statute, a code, etc., that's found to be repugnant to the foundational elements of common law. And so if a claim is brought to the court and the jury hears the case and they go back and they see that the claim that has been made with a law or a statute or code that's repugnant to any of our foundational documents, they can simply nullify that law and excuse the case at that point, or make other plans to deliberate or recase or rehear the trial based on another claim. So in our world, you are considered innocent until proven guilty. And in opposition, Roman civil law requires that judges and attorneys abide by the state's legislation or their policies, and the court must apply to each case. That's what they're told to do. The state is saying, you will apply those statutes and codes to this case. Their law policy speaks in prospect to the legislative statutes, codes, and mandates where civil or criminal law is involved. There's no room for finding innocence with foundational documents in that regard. In fact, when you walk into the courtroom, you probably have already been at least ticketed, if not arrested, and charged with something. And now they're going to take your evidence and they're going to try and pin it to that charge. That's called the color of law. That's how the de facto courts work. They're trying to build a case against you instead of finding your innocence. Here's the worst thing. After both the claimant and the accused, or in this case, the defendant and the plaintiff, after their testimony, the attorneys get a chance to speak on behalf of the plaintiff and the defendant. And these are called closing arguments. Now, in closing arguments, the prosecutor or the defense attorney is trying to build their case against either the plaintiff or the defendant. So what they do is they create this big speech. They lay out the statutes, codes, or laws that they supposedly violated, and then use the evidence that was presented to strengthen the argument for that guilt or innocence. Now, the defense gets a chance to do that, and so does the prosecution. But basically, after the jury hears the argument of the prosecutor and the argument of the defense attorney, the jury is going back to deliberation with only two options. They either have to find for the prosecution or find for the defendant, based on the argument that bar attorney gave to the jury. So the jury doesn't have a lot of leeway. They don't have any thinking room. They can't think out of the box. There is no foundational documentation when the jury goes to their decision making. They can't go out beyond it and look at the 10 Commandments or look at natural law and say, yeah, well, but this guy did this and that, and they should be found innocent. There's no room for that in the de facto jury deliberation because of the way the court is run and because of the way the defense attorney and the prosecutor lay their case out for the defendant or the plaintiff before they go to deliberation. I think that's it in a nutshell for me. I hope people got a lot out of that. There's more involved. But we can certainly hold more podcasts in that regard if people have more questions.
Sounds good. Thank you, Randy. Appreciate you being here and speaking on that important subject today.
Sure. Glad to be here. Right?
Sorry. Thank you both, gentlemen, for this important topic, Randy. Civil versus common law. It is a critical piece in us learning how we are different from the de facto and how the de jure operates. Our courts operate on the land and soil. So I want to thank you both. Thank you, Randy. Thank you, Bradley. Until next time, you can find our information at the virginiaassembly.land. Thank you.
So long.